Can I use small claims court instead of arbitration for real estate? Have you ever wondered if you can opt for small claims court instead of arbitration when dealing with real estate disputes? This question is essential for anyone involved in real estate investing. Let's break it down together. In real estate transactions, many contracts include arbitration clauses. These clauses requiring parties to resolve disputes through arbitration rather than going to court. This means that if your contract has such a clause, you are typically bound to arbitration for any disputes that arise. Ignoring this clause could lead to your case being dismissed in court. Small claims court is designed for simpler disputes, usually involving smaller amounts of money. The specific limit for claims varies by jurisdiction, often set at a few $1,000s. This court offers a quicker and less formal way to resolve issues without needing a lawyer. However, it is not the best choice for complex real estate matters or disputes involving larger sums. Arbitration, on the other hand, is a private process where an arbitrator hears evidence and makes a decision that both parties must follow. This method is often preferred in real estate because it can handle more complicated issues. It allows for expert decision-makers and tends to be faster and more confidential than traditional court proceedings. When considering whether to use small claims court or arbitration, think about a few key factors. First, check your contract for an arbitration clause. If it exists, you will likely need to go through arbitration. If the dispute is minor and the contract does not require arbitration, small claims court might be an option. Next, consider the size and type of your dispute. Small claims court is suitable for smaller claims, while arbitration is better for larger or more complex issues. The formality of the process is another point to consider. Small claims court is informal and allows you to representing yourself, which can be beneficial for straightforward claims. Arbitration can be more formal and may involve legal representation. Another aspect to keep in mind is the finality of decisions. Arbitration decisions are usually binding and have limited grounds for appeal. In contrast, small claims court decisions may allow for some level of appeal, depending on local laws. Lastly, think about efficiency and cost. Arbitration can be quicker and less expensive than traditional litigation, but may be more involved than small claims court. Small claims court is often the least expensive option, but it may not be available for all real estate disputes. As a real estate investor, it is essential to negotiate arbitration clauses carefully. Understand when arbitration is required and if there are exceptions that allow for small claims court. If arbitration is mandatory, small claims court is generally not an alternative. If you find yourself facing a dispute, review your contract's dispute resolution clause first. If arbitration is not required, or if your issue falls outside the scope of that clause, small claims court could be a valuable option for smaller claims. Otherwise, arbitration is typically the designated method for resolving disputes efficiently.